Hello everybody, John and I have just finished recording the Spring PI Update 2021. We had hoped to be in person by this stage, but I think like the rest of you, we are somewhat slaves to this whole pandemic thing that's been going on for so long. I hope to see you all in person in the autumn, but for the minute, I think the thing you need to know is that A, this is virtual, but B, that doesn't mean there's not some really good stuff on there that you need to know. I mean, I know, John, you talked about the RTA stuff quite a bit.
Yeah, the courts are continuing work, the cases are coming out. On RTA, for example, with some really important decisions looking at how contributory negligence works in practice, really vital stuff if you're doing that sort of work. And of course, also on RTA, we take a look at some of the important procedural changes that are on the way. But there's plenty of info for you on EL as well, which Brett talked about.
Yeah, I mean, there are a couple of interesting cases. One of them are described as a positive outlook case, things that could be done, circumstances in which it might be possible that someone who disposes of work equipment may be responsible for what happens further down the line. That'll either be a really big case eventually or a nothing case, if I'm honest. More interesting was one called JPIL, which on the face of it looks like a vicarious liability case about someone being on a frolic of their own, but if you watch the update you'll see that it's actually really about direct principles or principles of direct fault, and you'll hear me saying that I think the High Court judge got it wrong. He may have got to the right decision, but his view of the law was wrong.
And then on public liability, we've got, well, a sense of deja vu. Do you remember the case of Bolton and Stone? The cricket ball being knocked out of the ground. It all happens again. Is it the same result? Is it different? Well, we'll update you on that. And also on occupiers' liability, a recent Court of Appeal case that is really useful on defining visitor, trespasser, obvious dangers, and the relevance of criminal proceedings as well.
Yeah, that is a really important one. That is the case of James against the White Lion Hotel, and it really does set the scene for why the Enterprise Act is something you should really always be thinking about, and why criminal responsibility still matters. Well, in essence, the judge got it right at first instance, but the Court of Appeal said, well, it's a little more nuanced than that. But the nuance is that it matters in relation to the breach in the case. Well, a health and safety requirement is going to do that. So as well as all of that, we obviously look at the usual CPR update, let you know what's going on. John's already alluded to the whiplash changes, which we cover in enough detail in this course so you know what decisions you can make in relation to whether you're going to do the work. But we also have a close look at some put under the microscope issues surrounding defendant dishonesty, which I'm sure John has a view on.
Yeah, some really interesting cases because we see these arguments so often. It tends to be one-way traffic, and these cases give us a bit of a view of the approach taken by defendants in those circumstances, and a reminder that there are sanctions that way round as well. And if you're thinking in all of this, are we still able to do the quizzes? Of course we are. And what have we got for you this time round? Well, part 36 again, because there's been another raft of cases, and then back after a couple of years, because I know it's everybody's favourite subject. We've got the service quiz. How can you leave it right to the last minute and still get away with it? That's what we're going to arm you with. Although, you know, if you can serve sooner, that really would be good, and just generally lower the pressure and the risk.
So if you took part in our Twitter poll about what John was doing the quizzes on while we were recording it, you now know the answer. And we finish off, or finish you off, depending on your view of things, with some cases on damages. We take a look at some general issues, particularly accommodation. I know you probably all heard about Swift v Carpenter before, but it's worth tuning in for John's take in relation to that. And we look at a couple of issues that do have a COVID angle, if you will. How you treat dividend income, which is a bit of a hot topic because of the way some of the COVID support measures have taken place. The key being the distinction between passive income from investments and income from earning. And we look at the approach a court will take if someone says, for example, in account schedule, aha, this should be less because of COVID. And really that is about knowing the basics. So it's really just about reassurance for you. So there's a lot there for you. I'm sure John may have a few last words that he wants to just fit in.
Yeah, it's all there. It's really important that APIL keeps up the training program because the law continues to move on. You need to be up to date, and we're going to make sure that that happens until we do get hopefully a bit more back to normal.